In this video, we're going to talk about the meaning of a patent and how to patent an idea. Hello everyone, my name is Babak Aklagi, a patent attorney with Novotech IP International, where we secure your assets through intellectual property, IP for short. If this is your first time here, please click the subscribe button. The links to everything we will mention in this video are also below. Please make sure you stay until the end, where I'll share a tip on how to avoid losing your patent rights. Let's get into it. What is the goal of patent law? The goal of patent law is to promote the progress of science. It does this by encouraging inventors to disclose their inventions to the public. In return, the government protects the inventions for 20 years. U.S. patents are available for technologies that are useful, new, and unobvious. However, ideas such as processing mathematical algorithms or performing activities that could otherwise be performed by humans cannot be patented. They are considered abstract. Here are the steps to patent an idea. First, you need a patent application. Second, you need to file the patent application with the United States Patent and Trademark Office, also known as the USPTO, or just PTO. Third, the patent application needs to be examined by an examiner at the USPTO. If during the examination, the examiner deems the application is allowable, then the application is ultimately issued as a patent. However, if it is deemed not allowable, it is ultimately rejected. Let's turn our attention to the first step. Obviously, you need an idea. However, after you have your idea, you need to identify a registered patent practitioner to prepare a patent application for your idea. A registered patent practitioner is normally a registered patent attorney. Patent attorneys have two licenses, one general license issued by the state bar in which they practice law, and one license issued by the USPTO. To obtain the USPTO license, the patent attorney must have a scientific background with a minimum of a bachelor's degree in engineering or another scientific field. They must also pass the patent bar exam administered by the USPTO. Once you have identified and engaged a suitable patent attorney for your invention, you can then disclose your idea to them. Don't worry about signing a non-disclosure agreement, also known as an NDA, with the patent attorney after you engage them. Your communications with the patent attorney are legally protected under the attorney-client privilege. The disclosure of your invention to your patent attorney can be done in three ways. 1. It can be done over the phone. 2. It can be done over video conference. Or 3. It can be done in person. These days, most disclosures are done either through the telephone or video conference. I personally use Microsoft Teams for the majority of my disclosures. An invention disclosure normally takes about 1 hour. The patent attorney will ask you about how you will make and use your invention. It's important to provide your patent attorney with any technical documents that you have describing the invention during or before the disclosure meeting. It is preferable to do it before the disclosure meeting, so your patent attorney will be better prepared. It will also result in a more fruitful discussion between you and your patent attorney. After the disclosure, your patent attorney may conduct a patent search to identify or assess the patentability of your invention. Basically, they want to make sure your invention is actually new. Assuming the patent search results are okay, your patent attorney will move forward to prepare a patent application for your invention. The patent application is both a technical document and a legal one. It describes the manner of making and using your invention, and it also describes the boundaries of the invention. So, it is very important that your patent attorney has the relevant technical background in the field of your invention to fully describe your invention in the application. If he or she does not, then your application may be flawed and rejected. Let's move to the second step, filing the patent application with the USPTO. This step involves submitting your application with formal documentation to the USPTO. These include an assignment, power of attorney, inventor's declaration, and an application data sheet. The third step is the examination of your patent application with the USPTO. During the examination, your application is assigned to a patent examiner who has the relevant background in the field of your invention. An examiner normally has many applications assigned to them, so it could take a few years for the examiner to pick up your patent application and start reviewing your invention. During the examiner's review, they will conduct an online search to determine the patentability of your invention. The examiner will set forth their findings in a written communication, which is referred to as an office action. An office action sets forth reasons for rejecting your application. To reject your application, the examiner usually relies on one or more references, such as prior patents or prior publications, and alleges those references teach your invention. The examiner will mail the office action to your patent attorney. The office action must be responded to within 3 months, although up to an additional 3 months of time can be obtained for response by payment of a fee. The response must address all issues raised in the office action. An important component of the response is the remarks, which is a written statement explaining how the response has successfully addressed the rejections, with particular emphasis on how the invention is different from the references found by the examiner. You will work closely with your patent attorney to develop a strong technical argument supporting patentability of your invention. Care must be taken during this time to draft a strategic response, because anything said becomes a part of the public record and can be used against your patents in the future. The examiner, taking the response into consideration, may issue an allowance of the application for passage to issuance, or may issue a second office action if the response is found not to be persuasive. Similar to the first office action, the second office action needs to be responded to within 3 months, which is extendable by an additional 3 months with payment of a fee. This back and forth between your patent attorney and the examiner is often referred to as the prosecution. Ultimately, the prosecution of your application will either result in the allowance or a final rejection of your application. If your application is allowed, it will go on to issue as a patent. However, if your application is rejected and all appeals are exhausted, then it will ultimately become abandoned. In the next video, I'll talk about why patents are so important and how they can be used to strategically boost profits. But before we conclude, I promised a tip at the beginning of this video. And that tip is, don't disclose your invention to anyone, of course, other than your patent attorney prior to filing your patent application. The reason for this is that as soon as you disclose, in a lot of jurisdictions outside of the US, the invention becomes part of the public domain and can no longer be protected. Thankfully, the US gives you 1 year from the date of public disclosure to file your application. Here is a second tip. If you wish to expedite the prosecution of your application and don't want to wait several years for the examiner to review your case, there is a mechanism for that. Your patent attorney can file with the application a formal document called a Request for Expedited Examination. Once it is filled, it will result in the examination of your application within a few months, and the Patent Office will guarantee a final result, allowance or final rejection, within 1 year. Thank you for tuning in. If you liked this video, please click the like button.